In this training module, I'm going to explain the typical patent filing process and timeline. This includes starting with a U.S. Provisional Utility Patent Application, and later filing a U.S. non-provisional utility patent application, and potentially filing one or more foreign patent applications. By the end of this training module, you should be able to have a basic understanding of the standard timeline involved with the patent process. Let's get started. On the screen, I'm showing the typical timeline for a U.S. patent application process. This includes filing both a provisional utility patent application and a non-provisional utility patent application. This timeline is labeled with a couple different points in time that are important in the process. All of the other things that happen in between are less important than these times. This timeline begins when the provisional patent application is filed. I've labeled that as month 0 or M0 at the bottom there. Within the next 12 months after you file your provisional patent application, you'll think about filing your non-provisional patent application. In this slide, I've also labeled that as M0. You'll notice that duplicates the M0 designation for when you file your provisional patent application. This is because filing the utility non-provisional patent application actually doesn't eat into your 20-year term of your non-provisional patent application. There are two ways to file the non-provisional patent application and still claim priority back to your provisional. One of them is never used, and it's officially referred to as converting the provisional application into a non-provisional patent application. The official conversion process is not actually used. I've never seen it used in all my years of practicing, and there's no benefit to using it because it actually eats into the 20-year term of your patent. The other way to do it is to file a claim for the benefit of priority without actually, technically, converting the provisional application into a non-provisional patent application. Now this gets a little bit confusing for a lot of people because most patent attorneys usually shorthand the description of filing the claim for the benefit of priority to just simply stating converting the provisional patent application. This is technically incorrect, but it's what you'll hear probably every patent attorney talk about when they say converting the provisional patent application. They really mean they're going to use the process of filing a claim for the benefit of priority of the provisional patent application so that they don't eat into the term of the non-provisional patent application that you're filing. That's the right way to do it, even though the language is a little bit confusing. I've labeled the filing of the non-provisional patent application as month 0. Again, because that's when your 20-year term technically will start, even though you filed your provisional patent application sometime before filing your non-provisional patent application. Sometime within about 12 to 18 months after filing your non-provisional patent application, your examination will probably begin. Now this time frame can be different depending on a couple different factors. We talked in a prior module about the ability to accelerate examination using some of the different protocols and procedures available through the U.S. Patent and Trademark Office. If you use those programs, you'll probably be able to see your examination start well before the 12-month period. In fact, you might even be able to get through and completely finish the examination process by 12 months after filing your non-provisional patent application. However, in normal instances, your examination won't begin for about 12 to 18 months, and in some technology areas, a lot longer than that. When it does, it'll take another 12 to 18 to 36 months to finish up the examination process. That will depend on a lot of factors, of course, primarily how fast the examiner can turn around the case every time that you respond to them, as well as how quickly you can turn around your responses. Typically, you have up to 3 months without filing any additional surcharges. But if you want to file surcharges or you need to file surcharges, you can actually respond to most actions in a 6-month period. So you could see that going back and forth even 3 or 4 times with the patent office at 6 months each time, plus some delay at the patent office side by the examiner, could easily result in over 2 years in just the examination process. After the examination's over, or at the completion of the examination, you'll find out if your patent application is going to be allowed and issued, or you might make the decision that you've gone around with the examiner too many times and that your opportunity to get a patent is very limited, or perhaps your opportunity to get a valuable patent is very limited, and you might decide instead to suspend or abandon the process. This can be frustrating because it's a lot of effort to get to this point and a lot of time and investment, but we don't ever know exactly what will happen until we're in the middle of the examination process. And so it's just understood that different things can happen, and we hope for the best and we try our hardest to get these issued, but they don't always get to that point. And we have to make decisions to suspend prosecution because there might be better ways to use the time and money that would otherwise go into additional examination of the application. So this is a standard timeline for the provisional and non-provisional U.S. utility filings. You'll see that this slide repeats the same U.S. process on the top line. In addition to that, this slide also shows one option for filing your patent application in foreign countries. This process is a two-step process as shown here. First, you have the opportunity to file what's called a PCT patent application. PCT stands for Patent Cooperation Treaty. This is a treaty that's entered into by many, many countries around the world, although not all of them, and allows you to file and claim the priority of your provisional application if it's filed within the same 12-month period after your provisional application is filed. You'll notice that the PCT filing date on the lower line is labeled as month 12. This is different from the U.S. filing, which is labeled as month 0 for the non-provisional patent application. This is because the PCT process is triggered and timed from the date that the provisional application is filed rather than the date that the non-provisional patent application is filed. The total timeline for the PCT process is usually between 30 and 31 months. At this time, you will need to decide if you want to enter your application into individual countries or into individual jurisdictions that cover multiple countries. For example, Europe can be entered into as a jurisdiction as a whole prior to entering into individual countries. There are other organizations or associations that allow you to enter into a region rather than into an individual country first. But ultimately, in order to get patent rights in any individual country, you will need to go through a process in that country or a process that that country recognizes as official so that it can be granted in that country. So the PCT process is an international process. It doesn't result in a patent, but it buys you the opportunity to extend your decision for filing in individual countries sometime between 30 and 31 months from the very first date that you filed an application, which in this case will probably be your provisional patent application. When you reach the 30 or 31 month date, you'll decide on which countries you want to file in. And remember, these will need to be countries that are members of the Patent Cooperation Treaty. If you want to file in countries that are not members of that treaty, you'll need to follow the timeline in our next slide, which I'll show you in a moment. Once you file in the member countries of the PCT, you will then begin a process that's similar to and parallels the process in the United States, where you'll file the application first, and then at some later point, you'll begin an examination process, and you'll end up either getting an issued patent or suspending or abandoning that application. You can see that this is a pretty extensive process. You can also count on a lot of costs going into this process, which is why the provisional patent application process is so attractive in most instances. Although it only buys you a 12-month period, you can make a lot of progress, if you try really hard, to find out whether or not the business behind your invention will justify the costs associated with pursuing the official U.S. non-provisional patent process and one or more international or individual foreign patent processes. Cost-wise, there's a huge cost difference. The provisional patent application process, if you're doing it through the workshop, will cost you only the filing fee for the U.S. government. If you engage an attorney, you'll pay those attorney fees also on top of that, which normally could be in the range of between about $1,000 and $5,000, depending on your technology and the law firm or attorney that you hire. From there, filing a non-provisional patent application can cost normally between $6,000 and $15,000. And the examination stage can range anywhere from about 50% of that cost to 100 or 150% of that cost. You can see that even filing just in the United States, the non-provisional patent process can add up very quickly. If you decide to also file a PCT application for international opportunities, the filing fee alone for that currently is in the $3,500 range, and a law firm will probably charge you another $1,000 to $2,000 to do that. Once you get to the foreign filing stage, around months 30 and 31, you'll then need to file in individual countries, which can get very expensive. I often have told clients in the past to plan on anywhere from $2,000 to $10,000 or $15,000 to get into an individual country, depending on the country that you're going into, the filing fees that are required there, the foreign law firms that are involved in the process, and any translations that might be required to put your patent application in the correct language. Examination, again, in those individual countries can be very expensive, and in most foreign countries you'll find that there are annual annuity or renewal fees required just to keep your patent application pending. The U.S. process doesn't have those annuities during the examination stage. They only require annuities or renewal fees 3 times after your patent is issued. But foreign patent applications will often require an annuity just to keep your patent application pending in the process, either before or during examination, in addition to any maintenance or renewal fees that are due after your patent is granted in those countries. So you can see that will add up extremely quickly, which is why using the provisional patent application process wisely is extremely important. This slide presents one alternative that's very similar to, but slightly different from, the prior timeline in the prior slide. Here, an applicant can file a provisional patent application at month 0, and then instead of filing both a U.S. non-provisional patent application and a PCT international patent application, the applicant might decide to file only the PCT patent application. Then, at the 30-month mark, the patent applicant will decide whether or not they want to file in foreign countries, as well as whether or not they want to file in the United States. This, of course, delays the entire process. It can delay some of the fees involved in the process, but it also delays how soon you can get your patent issued in the United States. So I've seen a lot of inventors who do not want to use this process because they are very anxious to get a patent issued in the United States. So they prefer to file in the United States at the 12-month mark, simultaneously with when they file the PCT application for foreign countries. And you should also note that just filing a PCT application doesn't require you at the 30 or 31-month mark to ever file into individual countries. If you determine that you don't want to do that by then, you can just let that PCT patent application essentially expire, similar to how your provisional patent application expires after 12 months. In this slide, you can see that the provisional patent application is filed at month 0. The U.S. non-provisional patent application is filed at the new month 0, sometime 12 months after the provisional patent application is filed. And here, instead of filing a PCT international patent application, you can actually opt to file directly into foreign countries by the 12-month mark. Instead of using the PCT rules to file one international application and buy additional time to later go into individual countries, you can file under what's called the Paris Convention, or PC, to file from the United States into individual countries. The individual countries you file into need to be members of the Paris Convention. Otherwise, you would need to file directly into those countries. However, there are very few countries that don't participate in the Paris Convention or the Patent Cooperation Treaty. After filing in a foreign country, the examination and other processes are the same as what we've described before. So you can see that there are a couple different ways that applicants might pursue patents in the United States and foreign countries. None of them is right or wrong. It's just what you decide is best for you according to the timeline that you're on, according to the life cycle of your technology, according to your budget, and according to your geographic and global potential with your invention. And that's it. You should now be able to start to think about and anticipate the timeline you might want to follow with your patent process.